articles and memorandums alteration. There is a specific procedure in how you can alter the memorandum and how you can alter the articles. Now, alteration in memorandum, save as otherwise provided in the section 61, which is under the issue of capital and further capital of shares. Otherwise, except section 61, the company can pass a special resolution and you can change or alter any one or the more of the clauses of the memorandum. It is defined in the section 13. Now, being very specific, for changing the name of the company, you need to pass the SR. We know that, and you need to take approval from ROC, and the ROC will issue a fresh certificate of incorporation under the new name, and then only the name will be made effective. The change in name will be made effective. So what we require to alter the name, you need to pass the special resolution and you need to take permission from the separate certificate of incorporation, a new certificate of incorporation from the registrar of company. Second is the situation clause. Then if you are registered office, you need to change the registered office from one state to another. Then you need to pass, of course, the SR, which is a basic requirement. Apart from it, above the ROCs and ROC is for one state, but you are changing from one state to another. Which ROC will you take the permission? No. In this case, the hierarchy will be different. Above the registrar of companies, there are 7 or 8 regional directors in India, RDs, right? They are also the Ministry of Companies Affairs mechanism, hierarchy in the MCA. So you need to take the permission of regional director that you are changing your registered office from one state to another. So you need to pass the SR. You need to take the permission of RD in case of change in registered office from one state to another. Now, once you apply to the RD is bound to reply you within 60 days. The RD shall dispose the matter within 60 days. And before making such order, the alteration has the consent of creditors, debenture holders, and any other party, that either for the due discharge of all the debts and obligations or a adequate security has been provided. What we are trying to say is, if you are changing your registered office from one place to one state to another, the RD will confirm this from all the debenture holders and loan providers of the company, that are you having any objection because the company is shifting its office from one state to another, because these are the persons whose funds are being stuck in the company. If the company changes its registered office from one state to another, their fund may get affected. How they will recover their funds if their registered office is changed? So the RD will take specific permission from the creditors and other debenture holders, and they will ask all the creditors and debenture holders that if you have any objection to it, you can submit the same. If no objections have been received, then the certified copy, then RD will approve the alteration, that is the amendment from one state to another. And then after receiving the copy of RD, then the company shall file such document to the ROC that I had already received the permission of RD. Now issue me the fresh certificate of incorporation with the altered address. आरडी की परमिशन मिलना is something different. आरडी की परमिशन मिल गई इसका मतलब ये नहीं कि रजिस्टर ऑफिस चेंज हो गया. आरडी की परमिशन मिलने के बाद you need to apply for the change in office to the ROC, and then the ROC will issue you fresh certificate of incorporation with the new address. Simple. Then for object clause, of course, you need to, if you have raised money from public through prospectus, that means IPO, FPO, offer for sale, you are already having some funds raised from the public. And if you want to change the object clause, that means, this is a very simple example. Say, for example, you had taken up funds from IPO and FPO, saying the public that you will be in the steel business, say, for example. Now, after taking the money for the steel business, now you say, no, our object is changed. Now we will not produce steel, we will do chemical industry business. So the shareholders have not given you the funds for the chemical business, they have given you the funds for steel business. How can you change the objective after taking the funds from the public? So in that particular case, if you are changing the object clause and you have raised the money from the public, you need to pass the special resolution. First thing. Second thing is, you need to publish such special resolution in at least 2 newspapers, so that if any shareholder is unaware of the fact, they must also know it. जरूरी नहीं है सारे शेयरहोल्डर्स को ये सारी चीजें पता हों, तो भी एक जनरल न्यूज़पेपर एडवर्टाइजमेंट एटलीस्ट 2 न्यूज़पेपर में, वन इन इंग्लिश, one in the regional newspaper of that particular state, that we are going to change the object clause. Now, if any person wants to object, they can object. And after that, either the special resolution will be passed or not. Acha, if the special resolution is not passed, the company cannot change its object. Simple. But even if the special resolution is passed, normally it is that if the special resolution is passed, it is binding on all the members, whether you have consented or not, normally. But in the object clause, it is something different. The dissenting shareholders shall be given an exit opportunity. The promoters will take the shares of that dissenting shareholders and they will pay them the market value as defined by SEBI. What will be the manner of exit option is actually given under SEBI ICDR regulations 2018. Right? How the exit offer will be given. So after this particular point, we can jump to the SEBI regulations, ICDR regulations, that even if the special resolution is passed, you can change your object clause, no issues, you have successfully passed your SR. But the descending shareholders are not bound to be with your company with the changed object clause. And in that case, you will have to give them a proper exit offer price in a proper manner. And who is going to give them the offer? The promoters. So the promoters will take their shares, will pay them off, and they will set the shareholders free. Those who want to go in case of altered objects of the company. And how this SEBI, how this exit offer will be given? In the manner defined under SEBI ICDR regulations 2018. Company law has specifically highlighted the SEBI regulations. And the last thing we have is how the articles will be altered. That again, for the alteration in articles, you need to pass the special resolution. Even for changing your status from the private company to public company, or from the public company to private company. And if you are altering a public company to a private company, you need to have an approval of central government. Because a public company may, there can be n number of stakeholders. Now you are restricting yourself. That cannot be do so except the approval of court. That is, sorry, government, central. That is Ministry of Corporate Affairs. Before 2019, it was the approval of NCLT. Now it is a permission of Ministry of Corporate Affairs itself. You can alter your public company to the private company. And every alteration in the articles under this section, what will be the articles alteration? That if you are changing your company from public to private, you need to insert the restrictions, which is defined under the definition of company, private company, 2 clause 68. If you are changing your company from private to public, you need to remove those restrictions under 2 clause 68. And you need to alter the articles under the section, and within 15 days you need to file the alteration of the articles with the ROC. You need to give the amended articles to the ROC for the registration of the new articles. So this is all about the memorandum article and its alteration.